My name is Stephen Smith, and once again I'm delighted to be joined by Ian Quayle and my colleague Robert Kelly. Good morning to you both.
Morning, Stephen.
Morning.
Morning. Before I hand over, just very quickly, and I'll keep this quick today, just like to go over a few items so you can participate in today's event. As is always the case, you're listening by default through your computer's audio. You can join by the telephone if you wish, and that is toll-free and very reliable to listen through. You will have the opportunity through the webinar to submit text questions to both Ian and Robert, myself, by typing questions into the questions pane of the control panel. You can send in questions at any time, but we will have a designated Q&A, as is always the case, at the end of the session. Please also, if you need to get in contact, raise your hand during the presentation if you're having any difficulties with sound, or contact me on the chat function and we can try and sort out any technical issues you might be having. And also, if you would like to speak to us directly over your microphone and speakers, if you're feeling that brave, then do raise your hand and let us know if you'd like to speak rather than type the question out. Anyway, without further ado, I'll pass you on to Ian for the main part of the presentation today. Thanks, Ian.
Thank you, Stephen. Thank you, Robert. Yes, good morning, everyone, and thanks for coming along today. We're looking at reporting on title in a residential context, looking at what is good practice, what can catch practitioners out. I've also sort of touched on and referenced some issues relating to commercial reporting on title too, particularly as we've looked at in the past when we've dealt with sort of mixed use properties. I thought it was important to sort of give a nod to how we deal with the issues in connection with commercial transactions as well. I have within the notes given you some useful websites. Again, what I would refer you to today is the City of London Law Society that has a model form of report on title aimed at commercial transactions, but useful for anyone that is looking at creating a sort of model form of residential report on title. Of course, there are organisations such as PLC, etc., and most of the standard sort of precedent sources that you use will have a form of report on title, and it's worth having a look and a comparison at the different models just to see what's best, just to see what fits your sort of in-house style. And hopefully today we'll be generating some ideas that might make you think about what your report on title does do, and perhaps also what it doesn't do as well. So lots and lots of things to talk about. Again, thank you, Stewart Title. Thank you, Robert, Stephen, for giving me the opportunity to speak to everyone today. To start with, I've given you some useful websites. City of London Law Society, have a look at that model form of report on title. Remember, we talked in the past about leasehold transactions and the Leasehold Advisory Service, which has some background or peripheral information that is useful for you in connection with residential leasehold transactions. And if you've got a mixed use or commercial property, then have a look at the British Property Federation and leasing business premises on the government website, which again contains a sort of raft of ancillary information that can be useful to support the reports on title that you are generating or you are utilising. And again, I've mentioned in the past property protocols, the boundary dispute protocol there. Again, if we have a boundary issue that we're dealing with within the report, have a look at that site to give you an insight as to what sort of information we should be providing and the limitations relating to information that we're providing as well. So have a look at those. To start with today, is there a standard form of report on title? Well, the answer to that is no. And does there need to be a formal report on title for the client? Well, the answer to that is yes. Good practice certainly would require a written form of report on title being provided to a residential client. Commercial clients, you could, in your engagement letter, agree not to produce a formal report on title. In a commercial transaction, to be honest, you can agree whatever you want to agree with the client, but in a residential transaction, it is imperative that we're submitting a report on title to our client before exchange of contract. And the first point I want to emphasize with regard to a report on title is this, that we need to be careful how we structure it. We need to be careful that we take steps ancillary to the provision of the report to ensure that our client understands what we're saying to them, and so that we protect ourselves. So to that end, when we're submitting a report on title, be careful about supporting emails, Be careful about how we record what our client says in connection with the report, and be careful about the provision of information. Point number one today: don't send copies of documents without some form of explanation in a report on title. It's not enough, if I'm your client, to send me official copies of the register and say read that, and to send me copies of the TA forms and say read those. You would have to reveal that you have utilised the information that's been produced by the seller's conveyancer, information that's been generated by you in your due diligence process, and to an extent you've got to personalise the report on title for me. Okay, to that end, yes, supporting emails are going to be useful. I would always advocate that in it we are sort of translating or highlighting issues within the report itself, although the report should contain some form of summary dealing with those issues. If we are not going to meet with the client, and clearly that's going to be difficult, and clearly that's more and more unusual as we do more and more work online, it is imperative that there is some form of attendance upon the client via Zoom, via telephone call, etc., and that we keep a record of what's been discussed at that meeting, any concerns, any issues that the client has generated, and then that we communicate back to the client in writing with response, with additional information, or with clarification where that's important. And be aware of the fact that we should always be producing supporting information to a client in addition to the information that's contained within the report. So whilst I'm not saying you can send official copies of the register in isolation, there is nothing wrong with a report on title including them, as long as we are referring to the issues that we think are relevant to the client that are the official copies of the register reveal. So as far as this slide is concerned, it is important that what we are doing is we're generating information for clients that is meaningful, that enables our client to use the information that we are providing to make an informed decision about the conveyancing process. So again, a number of things that I've covered in previous webinars. Client objective. Why, Mr. Client, are we buying this property? What is your purpose? What do you intend to do? Second thing, remember that we've said all along the idea of a collective client doesn't exist, and that the report on title needs to be directed to our individual clients. And something I've just been working on over the weekend. Be careful on the basis that we maybe have clients that are acquiring a legal title, but there may be others that are acquiring some form of beneficial interest in the property. In those circumstances, be careful who we address the report on title to, and make sure that we exclude any liability for third parties reading, considering, or taking up the advice that we've given in connection with our report. So, for example, an insurer sent me an email last week, which was quite interesting, where in essence, Bank of Mum and Dad was providing some funding for a purchase of a property, and also providing funding for some modernisation and renovation works. And they had been provided with a copy of a report on title sent to the buyers by their conveyancers. And in essence, these third parties, the Bank of Mum and Dad, were utilising that to say, well, yeah, this seems a pretty safe bet. So be careful about all of those issues before we sort of go any further. The next point that I think is significant that I want to draw to your attention, if I can, is the issue about useful resources. PLC has a great precedent report on title. City of London Law Society has a certificate of title that you can use as a framework in connection with your report, and it also has a short form report on title meant for commercial transactions. But again, just as the certificate of title, it acts as a useful aid if it's on your desk or on your PC when you're looking at your report on title or creating a bespoke report on title for a client. Very important, I think, to have a look at some of the positions taken by the judiciary with regard to reports on title over the years and our role as a conveyancer. So within the notes, I don't apologise for the fact that I've looked at quite a lot of case law and extracted from that case law some of the points that I'm making on the slide here. Firstly, we are not, as conveyancers, as transactional property lawyers, general advisors. unless in our engagement letter, unless when we're scoping our retainer, we offer that we are prepared to give advice outside of the transactional work that we'd normally provide. Further, the courts seem to be saying there's no need to proffer unsought advice, so we don't have to express an opinion about a matter, unless, and here's where there's a caveat, unless the client is doing something so stupid or entering into a transaction that is so detrimental that any reasonable person would intervene and say to the client, hey, look, you really shouldn't be doing this. Flowing from that, there's no duty to advise about the commercial implications of the transaction. This is a good deal or a bad deal, Mr. Client, unless, again, it's so ridiculous. So if you're in a situation where you knew that a property had recently been bought by the seller at £180,000 and was now being sold to your client for £850,000, in addition to advising the lender, assuming there is a lender, there'd be an expectation that you'd be saying to the client, hey, there's something wrong here. You know, unless market conditions have altered radically, unless huge amounts of improvement works have been done to this property, it would appear that you're getting a bad deal. But no matter what we're doing with regard to our role, remember, at the end of the day, it's the client's call. Our responsibility is to produce to the client a report saying, hey, this is what we found out about your property. This is what we think about what we found out relating to the property. It's now your call as to whether you proceed or not. Remember, in the past, we've talked about informed consent. The last point on the slide is something that's important. And whilst I've been preparing for today's webinar, I've looked at this a lot. And certainly the courts seem to be saying, hey, you can't have a sort of standard trotting out of information for clients on the basis that every client is the same. It's important that you identify client objective. It's also important that you know your client, because what could be significant for you as a conveyancer, what might be significant with regard to what the client has told you with regard to their objective, may be ancillary to some other issues that the client has. In addition to the more obvious thing about, hey, we've got a nervous client, we've got a first-time buyer client, we've got an elderly client, we've got a client that's never been involved in this type of transaction before. So in all, in this slide, what I'm saying is it is important that we identify the scope of our retainer. It is imperative that we're telling clients about issues associated with title and nothing more, unless something is so glaringly wrong, so glaringly dangerous, creates glaring vulnerability for the client that we've got to point it out. Okay, and really that's common sense, isn't it? But this last point about we've got to think about individual client needs is, I think, very important indeed. And again, it's something that's sort of thrown across our desks on a fairly frequent basis by the SRA and by the Law Society. And certainly the cases that I've given you in the notes seem to confirm that position. Okay. I mentioned in the notes this case, which I'll just sort of show you in a moment or two. Yeah, this case of Hague against Wright Hassel and Company, which I'll come on to in a moment. Important that we understand our duty to explain. We can't, as I've said, just give clients basic documentation and say, hey, read that lease, read those TA forms, and everything is self-explanatory. It isn't, okay? It would be necessary to provide the client in a report on title with the information in the report itself, and then reference to the searches and other documents. Theoretically, the client is relying on the report and not the ancillary documents that are submitted in support. What does the client need to know? He needs to know whether or not he, or indeed she, is getting a good and marketable title. They need to know that what they're getting is something that's going to meet their objective and meet their requirements. They also need to know that as far as their lender is concerned, if there is a lender, that lender's needs and objectives are being met in connection with the acquisition. And significantly, and this is something that's overlooked, whilst we may be focusing in on this client and this particular transaction, I think in our report on title, it's also important that we highlight, hey, Mr. Client, you might be happy with this, you might be keen to proceed on the basis of what we've told you, but when you come to sell, or from a lending perspective, if there's a repossession, what we've told you about will have drastic implications on the marketability of this property or the ease of sale of this property. I think that's very, very important. Certainly when looking at negligence claims against conveyancers, frequently the claim arises or the problem arises on sale or on disposal. And therefore it's important that we don't just focus in on the needs of this particular client, but we also focus in on the needs of potential buyers, potential lenders or funders relating to this property. I mentioned this quote from Lord Justice Hoffman in the case that I mentioned earlier, the Wright Hassel case, that name for a firm of lawyers. Maybe situations where our client is commercially inexperienced and is deluding himself. And in those circumstances, what Lord Justice Hoffman says is we intervene and assist and provide guidance. We do more hand-holding than we would normally do. Examples. I've given you one with regard to purchase price. I've given you other examples in the past where we've had sort of funding issues, where the lender is being ridiculous with regard to their requirements or interest rates. But there could be a whole raft of issues which mean that we need to come off the fence and say to the client, look, you really shouldn't be doing this. And certainly Lord Justice Hoffman is, without sort of providing examples, highlighting that this may be necessary, where we've got a client that's commercially inexperienced. And that isn't just limited to first-time buyers, that's limited to clients that are buying a new type of property. And I mentioned this when we talked about mixed-use properties a while ago, that, you know, we might have a client that's bought lots of residential freeholds over the years, but now all of a sudden we're buying a mixed-use property, or we're buying at an online auction, or we're buying in a peculiar market, now being an obvious example, you know, with the SDLT window closing. How many clients in the past have had the threat of SDLT resurrecting itself and causing an additional financial burden in a transaction where currently the SDLT issue is no longer a problem? You know, how often does that happen? Never happened in the past. And how would a client know how to deal with the situation and what to do? Again, it might be necessary to step off the fence and give clients some advice about the commerciality of the transaction or the situation. So when we talk about the duty being owed to a client, what is the extent to which the client needs advice? Well, we've got to ask ourselves, is the client experienced in this type of transaction or not? Is the transaction unusual? And what's the scope of our retainer? In situations where we have inexperienced clients in novel situations, our report on title needs to emphasize their vulnerability or the limitations with regard to our due diligence exercises relating to the property that's being acquired. I think that's very important, and I think from the case law we can say certainly that those are issues that need to be addressed, as well as the standard sort of due diligence issues, which I'm going to come on to in a moment or two. The report on title should be provided before exchange of contracts. It should enable our client to reach an informed decision as to whether or not they wish to proceed. It may need to be updated. This is an important point. Once we've submitted a report on title to a client, it is important to understand that if additional information comes to hand, if outstanding information becomes available, then we need to provide that to the client and also vary or amend the report on title or add an addendum to it to highlight, hey, look, in the past our report on title said we were waiting for this, or we needed clarification on that. We've now had that clarification. This is the position. It is important that clients understand the position and that they give informed consent upon receipt of a report on title that they're happy to proceed. Without understanding the report, without having it explained to them in a manner that they understand, how can they be informed, and therefore how can they provide informed consent? So, number of points. Point number one, with regard to report on title, remember, no such thing as a collective client. It goes out to all the clients if we're dealing with a co-ownership situation. Two, we provide it before exchange of contract, but we are alive to the fact it may need updating or additional information provided. Even after an exchange of contract, there may be issues that are important to the client, even though the client has committed, and what we're telling them will not enable the client to extract themselves from their position. And the other point I think that's significant is this informed consent point, providing information in a meaningful manner. So, it's no good to a first-time buyer explaining, hey, look, the property is subject to a restrictive covenant, and then referring to a restrictive covenant on the title or in a lease or in a transfer. Better, in my view, to explain to the client what a restrictive covenant does and what practically are the implications of that covenant on this client given their objective. So again, we've got to be careful about legal terminology. We've got to be careful about the client that we're dealing with. Someone sent me an email last week, what happens if we've got a client who doesn't speak English and we're going to send a report on title to them? Well, in short, that report on title, unless it's in a language that the client understands, is meaningless. So what do we do? Well, either we get the report translated, or we make sure that the client has an appropriately qualified translator that can transmit the information to the client so that the client can give informed consent with regard to proceeding. A number of points. Don't simply copy in search results, title documents, or anything of that nature. We can send those documents to the client, but our report on title should refer to them. The client should have a client-friendly explanation as to what that terminology means. And we should be following up on the report to check the client understands and has any questions. So I think it's vital when we're sending reports on title to a client, we've got evidence the client's read the report, the client has understood the report, or perhaps more realistically, the client has told us that they understand. The client has been asked if there are any questions. If questions are asked, answers have been provided. Very important, and this goes across the conveyancing process. If a client asks you questions, have we responded to the question that's been posed and provided a satisfactory answer and had clearance from our client that they're happy with what we've told them? And remember, with regard to due diligence, if as a buyer's conveyancer I'm asking questions of the seller with regard to a matter that's been revealed relating to the title, have I got a satisfactory response? I can point you to loads and loads of negligence claims that arise simply because a buyer's conveyancer has highlighted an issue, has raised a question or inquiry relating to that issue, has had no response or an unsatisfactory response, but then moved on and not dealt with it. So absolutely essential, we're giving our client opportunity to ask questions, and where questions are posed, we are dealing with them. When we are dealing with a report, I think all of these points on slide are important, and we've touched on all in each one already. Has the client read the document? Has the client understood the document? Has the client been asked if there are any questions arising, and where questions are asked, have they been provided? And again, if we're dealing with a client on the telephone or via a Zoom conference or whatever method of contact or communication we are using, there is a danger that we miss something, we overlook something, we fail to record something. Where the client is emailing us, there is less risk of that. It's there on our screen to be dealt with. But if we're busy today and we're having an attendance with a client, going through the report or dealing with the questions that the client raises, and the client highlights something, there is a danger that that is missed. It is why it is essential that we keep on file details of our communications with clients, particularly in the current circumstances. We're all busy, a lot of us are working from home, and a lot of us will have situations where we're dealing with clients over the telephone rather than using Zoom or any other form of sort of virtual face-to-face meeting. Again, if we are talking to a client on a telephone, if we are having a Zoom meeting about a report on title, worth sending an email to the client. These are the things that we highlighted or discussed. These are the questions that you raised. These were my answers. Again, so if there's a problem at a later date with regard to information or advice that's been provided, you're not relying simply on an attendance note. You are clarifying the position, explaining the position, and hopefully protecting yourselves as a consequence. When we look at the report on title, it's important to look at its structure. And the first thing that I think is important is that we've got to have a connection to our engagement letter and to our retainer. Okay, so I think we should be highlighting to the client that this report on title is not covering certain items. So we're not dealing with planning, we're not dealing with environmental issues, we're not dealing with valuation issues, or we're not dealing with the commerciality of the transaction, given that it's a fairly standard transaction and given that you are an experienced client. We need to make sure the client understands what's not covered. And what's usually outside the remit of the report, well, I mentioned in the notes, state and condition of the property. The fact that as a conveyancer, you won't have inspected the property usually. Remember what I've said to you in the past, if you do ever inspect target property, you should tell the client what you are inspecting for and make sure the client understands that your inspection, your visual viewing of the property is limited to that issue. Planning issues other than the current planning status of the property and whether that planning status meets client's objective, again, is going to be outside the scope of your retainer. Other issues, well, there may be a whole raft of other issues that are relevant given a particular transaction or a particular objective. But it's your responsibility to make sure that there are no blurred lines with regard to your retainer and no blurred lines with regard to report. So it's quite clear to the client what you are telling them about and what you're not telling them about, which leads me to what our report should be covering. It should cover the terms of the contract, purchase price, issues with regard to what deposit would normally be paid and the nature of that deposit. Be careful with regard to reduced deposits. If a reduced deposit has been agreed, the buyer client should be aware in the report that if he defaults or she defaults at completion, the balance of the deposit will be payable. We should explain to the client the position with regard to insurance, the position with regard to vacant possession, and the significance of vacant possession, and any other special conditions in the contract. So, for example, if we've got items that are being left in the property that are chattels, the report should cover off the fact that we may not have undertaken any investigative work with regard to whether chattels work satisfactorily, whether they're subject to finance, etc. And although the seller will have explained the situation relating to those items within the TA forms, we won't have done any form of check to make sure what they're saying is correct. Again, not our job to check, highlighting or emphasizing to the client that is their responsibility. We should be referring to the client what the official copies reveal. Remember, quality of title, description of the property, where there are notices in the charges register, what those notices relate to. And this is where we sort of reach a first point of contention. How far do I have to go if there is a notice on the title relating to a restrictive covenant? Do I just have to tell the client about what that restrictive covenant is, or do I have to delve a little deeper? Well, my stance would be it depends on how significant that covenant is with regard to client objective. If it means that potentially we're going to fall foul of that covenant, then we need to go into a lot of detail. If, on the other hand, that covenant relates to, I don't know, not selling intoxicating liquor, and our client is buying this property as a residential property, then I think all we do is highlight its existence and perhaps just cover off that we haven't checked whether the covenant is in fact enforceable or not, on the basis that it's not going to impede on our client's objective, nor is it likely to impede on anyone else's when the property is sold, given the fact this is a residential property. Remember that when official copies of the register are explored as evidence of title, any ancillary documents referred to therein must also be examined as well. Pre-contract inquiries. Hey, Mr. Client, this is what the seller has revealed to us. We checked the information against the information on our file, and there doesn't appear to be any discrepancies, or there are discrepancies and we've made further inquiries. Remember, your job when you're acting on behalf of a buyer is to have a look at what the seller is saying and check that against information in your file. I would also be saying in a report on title that you should be using the TA forms as a checklist to satisfy yourself as to state and condition of the property, or to answer the questions that have been posed. Be careful with additional enquiries. The report on title should highlight that additional enquiries have been raised and what the response is. And where a response is awaited, that should be flagged up to the client. And the significance of the delay or the fact that information is not forthcoming at the time of report should also be highlighted. Search results. Again, not enough to give client a copy of the local search and additional inquiries of local authority. Not enough at all. You should be advising client about any adverse entries, obviously, and any entries that impact on your client's objective or that may impact on the client's objective. There might be things in there that might be worth pointing out to the client. For example, a new road scheme, or an issue with regard to smoke control orders, etc. Again, I was just looking this morning at problems with regard to pollution and wood burners, and the fact that local authorities are likely to get a little bit more interested in smoke control, given the amount of wood burners and given the pollutants that are being generated. So again, with regard to search results, we can't just say there's the result. We've got to explain to the client what the results are, adverse entries, and where adverse entries are highlighted or generated, what additional investigative work needs to be undertaken in order to close off or limit the potential exposure to the client. So the example I always give practitioners, if there's a tree preservation order, well, fine, tell the client about it, but so what? If we've got an inexperienced client, we should tell the client about what the risks associated with that tree preservation order could be, and the fact that it might be prudent to get a report from an arborologist. As far as search reports are concerned, again, we should be explaining to the client in our report on title the limitations relating to searches, and the fact that it may be that additional searches could be taken out, or title indemnity policies, or policies obtained with regard to old searches, etc. Not just saying, hey, there you are, Mr. Client, there's the searches, read them and come back to me if you've got any questions or issues. That isn't enough, unfortunately. If documents are referred to but can't be found, the report should deal with that and explain, hey, look, they're awaited from the seller's conveyancer. We'll tell you about them when they come in, or they're lost or missing, and therefore we're looking at a defective title insurance policy. And as we've explained in the past, if that is necessary, we can, in our report, refer to a title indemnity policy, and we need to make sure the client understands their duties and obligations relating to that policy. And as I've mentioned to you in the past, upon the conclusion of a transaction, I'll be highlighting to the client again their duties and obligations. Clients need to be aware of issues relating to survey and valuation. You must read a survey or valuation that the client obtains, and you must look to see if there are any title issues arising. And when I talk about title, I mean title with regard to issues such as overriding interests, title with regard to the extent of the property, boundary issues or boundary problems, etc. Again, if a survey reveals something that is obvious, glaringly obvious, that is a commercial issue, we should be reporting that to the client. So if we've got a situation where the valuer is saying the property is worth £80,000 and we're buying it £250,000, it's not enough to simply say, well, all right, the client's going to find out because the valuer is going to report to the lender, and the lender's going to come back and say we can't lend, or we can only lend X on the property. Not enough. We've got to drill that home to the client. That would be something that would be unusual, that would warrant immediate notification. We talked about plans in the past. Clients need to be aware of plans that are being produced and about limitations associated with plans. Rights that are benefiting the property should be identified and highlighted, so the client is aware of what rights there are, what rights are reserved, and how they impact on objective. Be careful with prescriptive rights that benefit the property. We've sort of explored that in the past and examined that issue. It is something that potentially is a real problem. Access rights to the property, again, Do we have rights of access and egress? And what about neighbours? If there are reservations and exclusions, we can't simply say to the client, mines and minerals are excluded. We should consider whether those rights are capable of being exercised. If there's anything in our investigation relating to title that highlights or reveals perhaps some form of intended development relating to mines and minerals, or anything else that is revealed that could potentially impact on title. Class of title highlighted. Clients should have explained to them that where we've got anything less than an absolute title, there are problems relating to state guarantee, land registry guarantee and indemnity. Where we are taking out a title indemnity policy, imperative that we explain the benefits of the policy, the duties and rights that are generated by the policy, and any limitations relating to it. I also mentioned in the notes about where we see notices in the charges register. Not enough to say there is a notice on the title protecting a restrictive covenant. We need to do more than that, particularly where that interest, that covenant, impact on the client. If it is of no consequence with regard to client objective, might it be of consequence with regard to a subsequent owner? I mentioned that whilst it's not necessary to go into details as to why rights and interests are enforceable in the report on title, it is important to check the position and to highlight any weaknesses or any potential problems. If we are looking at restrictive covenants that exist, we should be explaining to the client that it is possible for a restrictive covenant to be varied or removed. And again, I would refer you back to some of the very useful webinars that Stewart Title delivered and been responsible for relating to restrictive covenants that hopefully are still available for you to have a look at if you haven't already seen them. Unregistered land, again, I've given you details about checking the root document. With regard to the root document, have we got plans that are Practice Guide 40 compliant? Have we got a chain of ownership from seller in the root document to the current seller? Have we got dates in documents that correlate with chains of ownership with regard to land charges searches? Again, not necessary to go into that detail in the report. That's sort of sitting behind the report. But again, if there are searches that are outstanding or that need to be done, if there are gaps or omissions relating to the chain of ownership, then that needs to be reported to the client. Again, the client, if we're dealing with unregistered land, should have explained to them in the report on title the fact that in order to perfect this title, it will need registering at the land registry. So all of that is sort of fairly standard stuff. There are some additional points that I want to make, however. And this is something very important. Again, it's something that's just been sort of rammed home to me over the recent days when I've been looking at today's presentation. When you look at negligence claims against conveyancers, one of the things that you see with regard to reports on title and claims relating to reports on title is a failure to join the dots. In other words, look at the relationship between due diligence, title, and other issues. So, for example, if a search reveals the existence of service media in the land, then immediately you should be thinking about, well, are easements reserved to facilitate repair and maintenance of that service media? How does that impact on us as a client? If there are easements, but the search for the benefit of service media, but then the search doesn't reveal any service media, well, why? What's the problem? Again, I mentioned the fact that if a client wants to work from home and there are issues relating to restrictive covenants preventing home working, are we reporting that to the client? If there is nothing that precludes it, is the client safe from a planning perspective to use home as an office? And then I mentioned the point that is our report and title accessible? In other words, is it client friendly? Is it is it worded? Is it phrased such that the ordinary man in the street can get what we mean? The problem with dealing with conveyancing issues day in, day out is we get familiar with terminology and we think, well, a client's bound to understand what that means because everyone we ever talk to clearly does understand it. Well, no, that isn't the case. So just have a look, and again, be careful about clients where English is a second language, clients that are particularly sort of stressed by the transaction, anxious about the transaction, risk averse relating to the transaction, and make sure our report on title is addressing particular concerns. With regard to searches, I mentioned search results. It's not enough simply to give client a copy of the search result and say, there you are. Search results need to be checked, and the report on title needs to highlight anything that is adverse or anything that will impact, whether it's adverse or not, on clients' objective or purpose sitting behind acquisition. The limitations of searches should be explained to clients. And again, I've given you details in the notes concerning this. I mentioned the fact that searches may need to be updated or need to be protected by an indemnity, depending on how old the searches are, or the limitations relating to searches. I highlight and sing the praises of sim searches, particularly where we're dealing with complex registered land transactions, where we're buying a property that perhaps is composed of 2 or 3 registered titles. It's a residential property. I would do a sim search just to check the position. And again, any search that I undertake on the client's behalf, I should report to the client what the result reveals. I've given you in the notes 2 cases relating to searches, Orient Field Holdings and Bird and Bird. And what I've done here is looked at the Court of Appeal's stance in this case, which concerned solicitors who failed to advise on the results of a Plan Search Plus report. And again, this highlights a number of issues, but in particular, the Court of Appeal said, it is for a client to judge the impact of information, not for the solicitor, in essence, to act as a filter. So in other words, what the Court of Appeal is saying, provide information to the client, provide a view or an opinion of that information, and then the client's call is whether that's significant to them or not. You can't filter it and say, well, the client doesn't need to know about that, or it's of no real concern to the client. And again, I've given you Lady Justice Gloucester and sort of highlighted that in essence, it is important that clients are provided with information in a report on title so that they can make an informed decision as to whether to proceed or not. So what that case highlights is that we should provide the client with a plan search report or something similar in full, and then a summary of that report, and then highlight to the client any shortcomings or any need to seek additional information, clarification, or indeed information from experts. And on that particular point, I've given you AW Group against Taylor Walton, which again highlighted from a conveyancing perspective, hey, you're not a planning expert, but where there is an issue with regard to planning on an acquisition revealed by a search, you should be highlighting to the client what the search reveals and telling the client what steps can be done in order to clarify the position or to protect the client. In this particular case, getting some advice from a planning expert. So what can we learn from these cases? Limit the scope of your retainer. Where adverse search entries are revealed, report them to the client, advise what should be done next. It's not necessary to provide advice or a risk assessment on something that is outside your knowledge. You just simply need to tell the client, hey, we need specialist advice. This is the sort of advice that we need, or this is the information, this is the source of information that's going to assist you in your decision-making process. As far as TA forms are concerned, quite simply, check the replies to make sure all questions have been answered. Check to make sure that what you're told by a seller confirms or complies with what you have on your file or what's being revealed elsewhere by the seller's conveyancer. Always check additional inquiries. Does anything need following up? And what we should be advising a buyer. I mention this all the time. A buyer should be told that the TA form should be a useful checklist for the client so that they satisfy themselves as the state and condition of the property, and the questions that are posed To rely on a potential misrepresentation claim is dangerous. The report on title should refer to that fact, in my view. Client inspection. This is something that's frequently overlooked. Why should I, in a report on title, consider or dwell on what my client sees when they inspect, if they inspect? Well, in essence, we're not going to inspect the target property on our client's behalf, are we? Our client is deemed to have knowledge of anything that they actually see on inspection, that they should have seen had a reasonable inspection been carried out, or what someone else who was acting on their behalf saw when they inspected. Second point on screen here. We should be telling clients to report to us anything that they see when they inspect. And if they do see something, the obvious thing being someone in occupation other than the seller, we need to report that on in our title. If a surveyor or valuer or builder that's inspecting the property on the client's behalf sees something or produces a report that puts us on inquiry, again, that should be dealt with in the report on title. Frequently, this is overlooked on the basis that, well, the client already knows that. They've inspected the property. The client should be told to report back to you what they see or find, and you should then be deliberating as to whether or not that should be included in the report that you then send out to the client. It is not enough simply to say, well, the client's inspected, therefore I don't have to bother. I am particularly worried about this idea about someone on the client's behalf inspecting, because where that is referred to in a report or valuation, etc., that crosses our desk, we've got to, in our report on title, make sure our client is aware of it, on the basis that the surveyor or valuer may not have drawn it to the client's attention, or the client may not have understood its significance in the report or survey or valuation that they've seen and considered. I mentioned in the notes that additional inspections can be required exchange before completion and at completion, and again, not relevant to the report, but something that needs to be reported to the client if anything else is revealed in connection with those subsequent inspections that the client undertakes. Survey valuation and the duty to lenders. Our report on title should highlight whatever a surveyor or valuer has identified, no matter who they are acting for. The report should cover if there are any issues that have been highlighted or that require attention. The report should detail any matters of title that the surveyor or valuer has highlighted or revealed. Where the client is relying simply on some form of valuation, remember what I've said to you in the past about the Consumer Guide to Home Surveys. I would, in my report on title, if I haven't already, give the client a copy of that and say, hey, look, we've had a survey, we've had a valuation. This is the type of valuation that's been undertaken. That is not going to reveal everything that ought to be revealed with regard to your acquisition. That guide will explain the limitations with regard to some valuations and some surveys. In order to sort of finish today, there are some issues that I want to draw to your attention. Firstly, what's the report for? It's for your client. There may, however, be issues that you identify during the course of your due diligence process that warrant disclosure to lenders. And what I've done here is given you a case called Goldsmith Williams against eServe, 2015 decision, which highlights the fact that what we were aware of was a mortgage and a lender valuing a property and then looking to secure the loan on that property, but where the surveyor undertook a valuation and the valuation was far in excess of what it ought to have been. Lawyer aware of that fact, lawyer under an obligation to tell lender. The point I'm making here is that whilst our report on title, our due diligence investigations are for the client, there may be issues that our due diligence generates or that we become aware of that should be reported to lender. And remember, there may be issues where we're acting on behalf of co-owners who are acquiring a property, that we may have co-owners with a sort of divergence of objective, and therefore there may be issues that are of no real concern to clients 1 and 2, but are of particular concern to client 3. Again, we need to think about that and make sure that our report is addressing those issues. We should be ensuring that our report can only be utilized by our client. So again, I often see reports on title from residential conveyancers that don't take that into account and don't emphasize that this report is given to you, Mr. Client, and can't be relied upon by anyone else. How do we deal with incomplete due diligence in connection with a report on title? We highlight that our due diligence exercise is incomplete. We tell the client what we need to do, what likely timescale there is relating to it, and then it is for the client to determine, well, we don't proceed till we get that information, or I'm happy to proceed notwithstanding that information isn't available to me yet. Again, we would have to warn the client about exchanging contracts with incomplete due diligence and the potential problems associated with extricating ourselves from the contract where that complete due diligence generates a problem for us. How much detail do we provide to clients? Interesting one. I want to utilize as an example a restrictive covenant. If we have a restrictive covenant on a title, does that restrictive covenant impact on our client's objective? If it doesn't, and if we are satisfied that it's not going to impact on any subsequent owner, we simply tell the client about its existence, but specify that we haven't investigated to determine whether the covenant is enforceable or not. Where the covenant is going to impact on our client's objective, then we've got to do a lot more relating to that covenant. Is it enforceable? If so, by whom? Have we advised our client about the fact that it may be possible to apply to vary or remove the covenant, and explain to the client the mechanism and how cumbersome a process or how simple a process it might be, and what sort of cost vulnerability there is? How can we format a report so that we're producing meaningful information that protects us, that also assists the client? Well, in the notes I mentioned, when we're condensing information, we should have a look at some form of summary with regard to our report on title. There is, however, a large health warning. The health warning is this: I cannot and you cannot provide a summary to a report on title saying, hey, these are the things that we really need to watch out for or report to you, without emphasizing that there could be other issues within the report that may be significant that we haven't highlighted. But what I would do is say, you've told us your objective with regard to this acquisition is the acquisition of a residential property for you and your family. You are concerned that there is a facility that enables home working. Okay, if we do that, then we say, in summary, these are the issues that are potentially relevant to you. So, for example, I was just talking to someone last week, and there was a rent charge on the property of £1,000 a year in order for the upkeep of a path through some sort of landscape gardens. Okay, again, you know, given the client was buying this as a residence for himself and family, it's going to be a family home, it's nice that there is this sort of footpath, this sort of leisure facility to utilize, and the cost of the repair, maintenance, and ongoing sort of upkeep of this path seemed, according to a valuer and surveyor, not out of the ordinary given the size and extent of the path and the work that will be required for it. So again, you know, that sort of information may be relevant to a client given the client's circumstances. So we can provide summaries. The summary should highlight issues that are relevant to the client. It should also highlight any limitations with regard to the due diligence process and any issues or matters outstanding. That sort of covers the main issues that I wanted to cover today. Robert, I don't know if you've got anything to add with regard to specific policies that are available from Stewart's title. Hello,
Well,
Robert.
yes, Ian.
Stephen?
Can you hear me, Ian?
You're coming
Loud
through,
and clear.
Robert. Yeah.
Thank you.
Great. Yeah. No. I mean, obviously, there are policies where you identify problems like that, which are available. But always, as you've said in there, it is important to explain what the policies do to the client in your report,
Yeah.
and why you're proposing them as a remedy.
Yeah. Yeah, I think a lot of times with a report on title, that if there is a plug, I need to plug a gap with the title, the lawyer will take out a defective title insurance policy, but not deal with it in the report, and that's important. And I think the other thing again is with regard to problems associated with title, it's worth speaking to Stewart Title if you've got dealing with something that's out of the ordinary that isn't available in connection with an online application. But the report on title has to highlight the problem, highlight the solution, explain the limitations relating to the solution that the title indemnity policy generates. Stephen, I'm conscious of time, and I'm also conscious of the fact that I haven't given an awful lot of time for questions. Are there any questions?
Yeah, no, perfect. Thanks, Ian. We have some questions in. Just as a reminder, if anyone would like to submit a question for today's Q&A, you can do so by filling in the question section on your control panel, just typing it through there. That'll come through to me. But we've got a couple to get through, or a few to get through, I should say. So I'll start with them. Ian,
Yeah.
so we have a question from Fiona Knight. She said, cash purchase. Client had a survey. Should we insist that we see a copy? If the client declines
Yes.
file record of decline, the only option unless very unusual property or client.
Yeah, my advice is that if a client is buying a property and has a survey, then you should see it. If you haven't seen it, you need to limit the scope of your retainer and ensure that you are protecting yourself. But I have this question on a number of occasions. I've checked the answer with counsel on 3 occasions. And the point is that if your client is obtaining a survey or valuation of a property, you should ask to see it and you should consider it because it may contain issues pertinent or relevant to title. It may contain ancillary issues that you should be reporting in your report on title, but you've got to look at it and take a view. A few years ago, I dealt with a firm and they said they were worried about potential liability in connection with surveys. So in their engagement letter, they said, we're going to strongly advise that you have a survey, but if you have a survey, we don't want to see it, on the basis that they felt they couldn't advise on issues with regard to structure, state and condition. And I said, well, that's dangerous. You can't do that, because if a survey reveals an issue relevant to the title that the surveyor highlights, you need to see that to see whether or not further work is required on your part, or whether the client needs to be advised about what the surveyor has identified. If you don't see it, you're not going to get that opportunity. Does that
Just
explain that?
I think so, Ian. Thank you. Just as a follow-on from sort of my perspective, and sorry if I've misunderstood anything. I don't know the particular situation here, but what would be the reasons potentially for a cash buyer being difficult with this sorts of things? Is it just inconvenience, or could there be something more sinister? Or
well, again, it would be unusual for a client to say, "Hey, you can't see it."
Yeah.
I would be suspicious if a resident client of mine obtained a survey, and when asked if I could see it, he said no. I would want to know, well, what's the issue? Because there might be a myriad of different things that survey reveals that might impact on my advice relating to title. It would just be a peculiar thing to do, wouldn't it? I mean, I wouldn't automatically suspect, oh, there's some form of fraudulent activity going off. Although that might be the case, it's just a strange thing for a client to do. If you're asking, can I see it, and the client turns around and says, no, you can't, that's odd.
Yeah, no, actually, I mean, and sorry, but Fiona did come back on that and sort of point out that they're worried about the additional costs or potential additional costs there. So I think That's maybe where the issue is there.
Yeah, that would be part of your retainer, Stephen, to consider that survey. Only if the survey highlighted issues or defects or problems relating to title would you be entitled to then say to the client, I'm going to have to charge you more because that survey reveals X, Y, and Z that require me to undertake additional investigation. You couldn't charge a client extra for looking at a survey or evaluation. Just as you can't charge a client extra for giving advice about joint tenancies. You can give clients, you can charge clients more where you're severing a joint tenancy, where you're creating a deed of trust. But if my partner and I instruct you, Stephen, in a transaction, you can't say, hey, I'm going to charge you extra, giving you advice about co-ownership. It's expected that within the retainer, a standard residential conveyancing retainer, that you would be giving advice about co-ownership if it was appropriate. Just as with regard to a standard residential transaction, the expectation would be that you would see a survey or valuation and you would advise upon it. Only if the survey or valuation highlighted additional issues that warranted additional work or investigative work on your part would you be entitled to charge for it. So Fiona, I think if a client is saying to you, I don't want you to see it because you're going to charge me for advice relating to it, I think the client's misguided there, because I don't think you can charge just for considering it.
Perfect, thank you. Thanks, Ian. Hopefully, thank you, Fiona, for the question. Hopefully that's answered that. I have a couple of questions from Robert McNally. There's an insurance angle to this. I'll probably pose this to both yourself and Robert. So where following due diligence, a legal issue is identified, i.e. a lack of formal access rights over a road or track, and the solicitor advises that indemnity insurance could be made available, what is the duty of the solicitor, brackets, to its client, so far as that policy is concerned? If the solicitor fails to explain the wording or working, of the policy properly, is the solicitor rendering itself potentially in negligence, so that its PI policy is almost acting as a secondary level of insurance for the client?
Yeah, I think he is. I mean, I know, Robert, you and I have had this discussion on a number of occasions in the past. I know some firms don't take advising clients about the duties and obligations relating to the policy seriously, and I think it's important that they do.
I think you're right, Ian. I mean, the questions of disclosure and what you can and can't do once you have a policy are very important. And yes, I mean, our experience is that a lot of firms don't think to explain that to the client, or don't put it into the report on title. It's hidden somewhere in the terms and conditions or letter of instruction. But we have had cases in the office when we've had a call from a member of the public asking about a policy, and when we've dug down, it's not actually the person with the benefit of the policy, it's a neighbour, and the insured has been round waving the policy in their face, explaining why they're going to park on the garden or whatever. So I think that's a big issue. And the other one, obviously, is, as you've mentioned, and is so important, client's intention. It's very easy as a lawyer to say, there's a problem, I've solved it with a title policy. But ultimately, all we're going to do is give diminishing market value. And, if you have something like an HMO or a holiday let, and that's why you bought the property, the diminishing in value between an HMO and a 3-bedroom house may not be that much, but to the client, a real buggeration factor. And one, I'm on my high horse now, but one point I do try and stress to lawyers is, as is now more the case, you're being offered an existing policy that was taken out when the seller bought the property. There is tucked away in every insurance policy a bit that says it includes all of the proposal which was given to the insurer, and the proposal includes correspondence and emails. So unless you actually ask to see that, you can't give any advice to your client on how good that policy is. So you're giving false comfort if you say solved.
Yeah, it's true. Good point, Robert.
And as a kind of follow up to
Stephen,
that,
was that okay?
absolutely fine. Yeah, no, thank you, and that is very clear there. As a follow up to that question, Robert asks, when providing an opinion that title is good and marketable, could Ian just remind us what good and marketable actually means? And Ian, I know actually you've done this with our trainees before in the training you've done for them. So.
Yeah, of course. A good title and a marketable title are not the same. A marketable title is better than a good title, and in essence, what you're saying is that as a reasonable conveyancer, I am satisfied that for this purchase price, this property is marketable. In other words, it can be sold at the price it's being bought. A good title is significantly less advantageous. It's just confirming that the title, the legal title, would be acceptable to a reasonable conveyancer, having performed a reasonable level of due diligence. So a good and marketable title, a good title and a marketable title are two different things. What you're saying is, yes, as a lawyer, the title is good, and as a lawyer, you're also saying the title is marketable. In other words, it can be sold at the price that it's being bought. In essence, that's the distinction between the two. You're saying it is a good and marketable title. You are entitled to plug any gaps relating to the title with a defective title insurance policy. Great question from Robert.
Perfect, thank you. Thanks, Robert, for that question. A question from Mayumi. Mayumi asks that the client often says that the report on title is too long for them to read and will often ask for a summary. I usually say that they should read it as it's them who is buying the property. What would you advise to those clients who refuse to read the report on title?
Yeah, that's fine. If they do that, you advise them to read it. They tell you they're not. You warn them that I am proceeding on the basis you have read it, you have understood it. If you haven't read it, you haven't understood it, and we proceed, then you do so at your own risk.
Okay,
that's all you can do.
No. Absolutely, yeah. Thanks, Mayumi, for that question. Mark asks, if the property is in a former mining area, and there is no inkling of any future workings, would it be absolutely necessary to still advise upon a historical exception of mines and minerals?
Yeah, you advise that mines and minerals are accepted. You would explain the significance of that. The issue is, as I mentioned in my presentation, Stephen, is there anything else as part of the due diligence process that hints or alludes to the fact there will be some mining activity? So, there I'm thinking about planning or indeed anything else, or any activity in the vicinity that suggests that, the owner of the mines and minerals that are accepted is about to do something. That would be the point relating to it.
Absolutely. Okay, no, thank you for that, Ian, and thanks, Mark. Mark actually also separately asked, and Robert, it might also be worth bringing you in here, although I'm not sure I recall this personally, but Mark says, I recall you mentioning recently that there is a danger in accepting a pre-existing indemnity policy. What is the issue there? I could be wrong here, Robert. I'll let you lead on this, but I'm not sure if we would necessarily have an issue with a pre-existing policy. Or is that more for the conveyancer? I'm not sure where the angle is there, actually. But
well, it may just be the point
I think, Stephen,
at the end of the last question, which is that you need the policy itself isn't enough. If it's a bespoke policy, you need to know what information was supplied to the insurer. So see what evidence was given. So you should really ask for a copy of the correspondence that accompanied any application for a policy. Very few firms in our experience actually do this, but otherwise you don't know the background, how that policy was issued. So there are dangers there. Providing you are happy with it, then an existing policy is perfectly valid and good. You may need to top it up, which can be done either through the existing insurer or another one to make sure it covers it there. But I think it's just making sure you fully understand the basis that the the policy was issued on, to rely on it. Otherwise, it's a bit of false comfort, I think, in relying on it.
Yeah, Stephen, I've got a list of warranties that I'd want the seller's conveyancer to give me where there is a pre-existing policy, or questions that I'd want to ask the insurer. So was it Mark? If Mark drops me a note,
Yes.
or anyone else wants them, I can send you a copy of the questions that I would ask or the warranties I would seek where I'm getting a transfer of an existing policy. But Robert's absolutely spot on with what he's saying there.
Perfect, thank you, and thanks, Mark, for that question. There are a few more questions, but I think we'll come to an end there and take any more offline. Just a bit aware of the time, coming to 12:15 there. So thank you, Ian, as always, and thank you to everyone for logging in today. Just as a reminder, you will receive an email from GoToWebinar when you leave today's session. If you respond to that, that comes directly to me. So if you have any questions further to ones asked in today's sessions, then please use that email and I will receive those. You'll also, as always, receive a separate email from Robert, which will contain the slides and notes to today's section. So that just leaves me to say, on behalf of Stewart Title, Ian and Robert, thank you for joining us today, and have a great rest of your day. Thanks, everyone.